the most significant achievement of modern law in India is the constitutionalization of environmental problems by the Supreme Court. Discuss this statement with the help of relevant case laws. Now, this question is a short question. It is 150 words. So, we don't need to go into a lot of details over here when we talk about the cases or something. But we have to cover all the important points which are mentioned in the question. Okay. Now, first of all, before actually discussing this question, a small observation on this question which I can make over here is, if you look at this question, generally when we are studying, either if you have studied the environment topic many times while preparing, we are going through some of the Supreme Court judgments. But when we study polity per se, we don't study this topic at a place where we are discussing all the important judgments of Supreme Court with respect to environment. So in this question, if you see, either you could have used all your information which you have about the Supreme Court judgments. Some judgments we always refer when we are discussing the fundamental rights, where Supreme Court declared right to environment as a part of Article 21. Then we refer to some judgments when we talk about public interest litigations or judicial activism, which has resulted into cleaner environment. So we could use some of our information which we have from those areas to write this answer. Or there was a very important pointer which came in news this year only. So in my opinion, this question is again, it may seem to be something which is static, but it is very clearly coming from current affairs. There was an article in March, I think in some newspapers, about a Supreme Court judgment, where in that article, they had talked about some important principles which have been evolved by the Supreme Court over a period of time with regard to environment. So in my opinion, it was definitely a question from current affairs, which if you had followed it, you could easily attempt it. Okay. So let me look at the question again. The question is asking you that Supreme Court, its judgments have resulted into constitutionalization of environmental problems, and you have to comment upon whether this has been a very significant achievement of modern law in India or not. Okay, so there are two parts. One part is talking about this constitutionalization of environmental problems as a significant achievement of modern law in India, and second part we have to show how Supreme Court judgments have resulted into this constitutionalization. So what we can do is, we can have a short introduction over here where we can just, you can say, try to emphasize on what is the question asking. Okay, so when we say achievement of modern law, now remember, in today's time, what is the biggest threat we are facing as a human civilization? No doubt it is climate change. Every other problem which we talk about, you will see that different countries have differing opinions on them, but on climate change, at least everyone, notionally or in whatever sense, they are agreeing that yes, it is a problem. The degree to which the problem is, the kind of threat which it is making, and the kind of response we have, it may differ with different countries depending upon their own situations. But there is no denial of this fact that climate change has been acknowledged as a major threat today to humanity. So when we are talking about Supreme Court's judgments with regard to environment, definitely we can say that yes, it is a significant achievement of modern law. So with that note, we can start the answer. Okay. Then we have to focus upon this word, constitutionalization of environmental problems. Now remember, when we talk about constitutionalization, it is actually related to the word constitutionalism, which we generally study when we are preparing for this exam. We know what is constitutionalism. When you start studying polity, the fundamental word constitutionalism, it comes into our discussion. So constitutionalism, remember, it means two very important things. One is limited government, and second is it is lack of arbitrariness. So you have to show that Supreme Court, through some of its important judgments, has introduced some limits to the powers of the government or the state with regard to their actions in the field of environment. And the Supreme Court has introduced some rules or principles which have to be followed whenever any decision is taken in the field of environment. So to eliminate any arbitrariness in that field, that we have to reflect in our answer. Okay. So let us have a look at how to approach this question. Okay. So we will have an intro, a very brief one, say in one line, some 15-20 words. We can write that climate change or environmental problems are the most significant challenge to humanity, where the Supreme Court, through its judgments, has brought some sanity and has ensured that climate is protected, or we are taking some step towards sustainable development. On these lines, you can frame an introduction. Okay. Then you can talk about the constitutionalization of environment problems. Okay, so as I told you, there are two very important aspects when we talk of constitutionalization of things or constitutionalism. Limit to the power of government and lack of arbitrariness. Okay, so you have to show how the Supreme Court judgments have resulted into these two things when we talk of environment, right? Now, a very brief background we need to be aware of before attempting this question. You know, Supreme Court judgments, it came mostly in the 1980s and 90s. Of course, there were some judgments before that also, but the most significant judgments which we will talk about in this area, they are coming in the 1980s and 90s, and even today they are continuing. So one of the most important developments which took place in our constitution with regard to environment, it was the year 1976. Before that, 1972, what had happened, we all know. It was the Scotland, that Stockholm Conference. So after that, the significance of environment dawned upon us. And in 1976, we added Article 48A to the Constitution, where the state is now duty bound to protect the environment, forest, lakes, etc. Okay, we also added the fundamental duties, and Article 51A, there was a clause which expects all the citizens to protect the environment, right? So in the light of these two significant changes which were brought to the Constitution, and of course we had some subjects in our concurrent list. Okay, in concurrent list we had entry 17 and entry 17A and B. They are talking about environment. Okay, 17 is talking about prohibition of atrocities towards animals, 17A is talking about protection of forests, and 17B is talking about protection of wildlife. So very clearly there were provisions in the Constitution which were requiring the people. So I think it is 51G which is talking about environment. Okay, 51AG. So fundamental duties we had the DPSP which was requiring the state to protect environment, and there were some subjects in the concurrent list basically putting the onus on both the state as well as the union to protect the environment. So in the light of these things, the Supreme Court gave some landmark judgments where it brought some sanity, it brought some rules, it brought some principles to decide any dispute with regard to environment. That is what we have to cite in the answer. Okay, so one of the most important judgments which we could write in this answer, first one, the first principle which was used was, you know, right to environment was a part of right to life under Article 21. Okay, now this forms the base of everything. Once the Supreme Court declared that right to environment is included in the ambit of right to life, then it became very clear that if the state is making any law or any policy which is depriving any individual of his right to life, then the Supreme Court can strike that down, whether it is an executive decision or a legislative policy also, if it is violating the right to life, isn't it? We all know what is the purpose of right to life. So Supreme Court first of all linked right to environment with right to life through some various judgments. Any one or two you could have quoted that to mention in this answer. So one of the first cases was the RLEK versus State of UP 1982. You will find various names to this case, Dehradun quarrying case, and you may find 1985, 1988 multiple, because there were different judgments coming on the same issue over a period of time. So this could be cited. Then you have Charan Lal Sahu case 1991, and you had Subhash Kumar versus State of Bihar case 1991. So you could cite any one of these cases to mention that through these cases the Supreme Court declared that right to environment or right to life is a part of right to life. There are more cases. You have the MC Mehta case. A lot of cases are there with the name of MC Mehta versus Union of India. So any one or two cases you could have mentioned to show that through these judgments the Supreme Court declared that right to clean environment, right to clean water, air, they are a part of right to life. So henceforth, if the state makes any law which is depriving our right to life, that is, which is curtailing the environment, which is reducing the quality of environment, the Supreme Court can scrutinize it in the light of Article 21. Okay, so this was the first important legal principle which we had to show in this answer. Okay, then there were some other important principles which were used by the Supreme Court to decide some environmental cases. Basically, the Supreme Court introduced all the concepts which were introduced in the Stockholm Conference and other global reports on environment. So the principles like polluter pay, precautionary principle, intergenerational equity, all those principles were used by Supreme Court in deciding those cases. Okay, so the next principle, and as I told you, there was an article in, I think it appeared in the Hindu in March, where in single article they had mentioned all these principles. So if you had followed that, of course, you would be in a position to attempt this question very well. So it was the polluter pays principle. Okay, now the polluter pays principle, it was used in various judgments of the Supreme Court. What is this principle all about? If any pollution is caused by any, you can say industry or any kind of development activity, ultimately the responsibility lies on the polluter himself. He has to pay it. He has to bear the cost of it because he has reduced the quality of life of all the other people. Okay, so this polluter pays principle, it was used in the MC Mehta versus Union of India case. Now there are many cases which are of this name. Okay, you have some cases in 1985, 86, 87. Okay, the Ganga Tanneries case. Then you had the Shriram fertilizers case, which is also known as the oleum leak case. Then you had the Taj trapezium case later on, 2002. There are many cases where this concept of polluter pays was used with the name of MC Mehta case. Okay, और भी कुछ cases थे. There was Vellore Citizen Welfare Forum. Okay, this case 1996. In this case also there were tanneries located on the banks of the river in Tamil Nadu. So they had again used this concept to direct all those polluters to make the payments for it. So you could write that the Supreme Court in this judgment used the polluter pays principle and penalized the likely polluters for that issue. Okay, so you could use these cases. There are more cases, but even if you just write one or two of the MC Mehta case or any one of this Vellore Citizen Welfare Forum case, it could be sufficient for it. Now, next principle which was used by the Supreme Court was precautionary principle. Okay, precautionary principle. Now, what is this precautionary principle? It means that if you are doing something which is whose effects are not known, if you're doing something, it may cause some problem which we simply are not in a position to know right now. Something new is being done. Then in that case, we have to make sure that unless there is any doubt on what will be the exact result, we should not allow any such project. So this was the precautionary principle which the Supreme Court has introduced in the environmental cases. Now, very good example of this precautionary principle was the Narmada Bachao Andolan case. In this case, what happened? We all know the Sardar Sarovar project in Gujarat, it was challenged. So the Supreme Court in this case used this principle and said, we already have had enough number of dams made by human beings since thousands of years. So it is not that we don't know what will be the likely impact of a dam. So in this case, we are using this precautionary principle and we are allowing the dam to be built because we know what can be the likely consequences. Okay, but the same principle was used in another case, S. Jagannath case, where shrimp farming in the coastal regulated zone area, it was prohibited because we don't know what can be the likely result. So even if you just quoted one of the judgments and said that the Supreme Court used this principle to decide an important issue of environment, then you could be very easily placed in this answer. Okay, very well placed in this answer. Next important principle which the Supreme Court has used is the public trust principle. Okay, now what is this public trust principle? It again means that whatever resources are there, whatever environmental resources we have, it is basically belonging to the people and the state is just holding it as a trust. It is the state which is holding the resources of the people because of trust. So the state cannot destroy it without any, you can say, regard for the future generation. So the public trust doctrine, it is also coming from this intergenerational equity concept, right? So the Supreme Court used this doctrine. There was a very famous case, MC Mehta versus Kamal Nath case. Okay, this is again 1997 to 2000. There were 2 or 3 judgments on the same issue. So even if you just mentioned MC Mehta versus Kamal Nath case or the Span Resorts case, what had happened in this case? There was a resort built up which belonged to the then some relatives of the then Environment Minister, Mr. Kamal Nath, in the 1990s. So the resort was built in the banks of River Beas, and they had tried to change the course of the river. So because of that, a lot of problems were faced in the vicinity. So the people had filed the complaint, and in the case, Supreme Court used this public trust doctrine, and they imposed a very heavy penalty on the resort owners, and they called them to shut it down. Okay, so these are some of the important principles which you had to mention in this judgment, in this case, and mention about the judgment where this principle was used to ensure that there is some, you can say, principle, or there is some rule, there is some regulation through which the environmental decisions are taken. And the last one which you can mention is about the NGT. Okay, it was the Supreme Court judgments which were finally resulting into the NGT, National Green Tribunal, in 2010. So Supreme Court judgments in the MC Mehta case, 1986, then in the AP Pollution Control Board, versus MV Naidu, this was 1999. In these 2 cases, and there were some more cases where the Supreme Court had called for creating a special court or a special bench where experts will also be sitting with the judges to decide environmental cases. And as a result, the NGT was created in 2010 finally through the NGT Act, which is based on the principle of polluter pays. And it has experts as well as judges as members. So my whole purpose of mentioning all these cases was that at least you can, even for future, you can refer to some of these judgments, you can refer to some of these cases to, write some more, there can be questions in future also. And of course, it does not mean you have to mention all these cases in the answer, but even if you could write these principles and explain some 2 or 3 cases that where these principles were used, you could have scored very well in this question. Okay, so there are 3 very important points. First of all, you have to make this statement very clear that it is climate change is a big problem, and that is why the environmental laws, it is a big contribution of modern law in India. Second, you have to explain what is the meaning of constitutionalization over here. And thirdly, you have to elaborate that through Supreme Court judgments.